How activist can or should judges be? In the current conflicts around the rule of law in the EU and its member states, judges are often accused of being too activist. This is heard when, for example, they demonstrate on the streets against the government or file lawsuits against it. Others find it acceptable or even necessary that judges become active in public life. What are the arguments for and against judicial activism? Those who struggle with overly activist judges claim that the judiciary must be independent of politics at all times, because this is a vital element of the rule of law. In this perspective, any public activism for political aims carries the risk that judges move beyond interpreting the law made by elected politicians. They become politicians themselves. Activist judges might then also use leeway in interpreting the law to treat plaintiffs worse whose motives do not correspond with their own personal preferences. This would damage the right to a fair trial, another important element of the rule of law. Moreover, a one-sided court decision can pave the way for further one-sided rulings in other cases. This risk is especially high if the activist judges serve in the highest and most influential courts. Other judges may then feel bound to these activist judicial decisions, even if they personally find them inappropriate. Thus, just like in a game of dominoes, established norms set by democratically elected majorities in parliaments could topple. Even if this is not the case, the mere impression among the public that judges might rule in a biased manner damages the rule of law. Others argue that the activism of judges can be acceptable or that it is even necessary in certain situations. They agree that courts must take their judicial decisions independently from politics. However, judges are also citizens. As such, they have the right to commit themselves for the common good as long as this is in line with the law. According to defenders of judicial activism, it is sometimes even the very duty of judges to become active and use all means they have. An example would be when political and other forces try to systematically undermine the rule of law or democracy, as enshrined in the constitution of the member state or the EU treaties. Such activism would not serve to favor any particular party or ideology, but to safeguard the constitutional order and protect the rights of all citizens, regardless of which party they support. Those who share this view claim that under such circumstances, activism would not lead to one-sided misinterpretations or reinterpretations of the legal order. Instead, it would contribute to proper interpretations of the law and constitution. In this perspective, activism to safeguard the rule of law can contribute to ensuring all of its elements, including the right to a fair trial and judicial independence. So, how activist can or should judges be? What do you think?